Welcome to our program tonight. I'm Doris Wise-Montrose, President of Children of Jewish Holocaust Survivors. Our speakers tonight are, in order of their appearance, Professor Avi Bell, who holds multiple degrees from Harvard and the University of Chicago, clerked for the Supreme Court of Israel, and has taught courses on the laws of war and the legal aspects of the Arab-Israeli conflict. He is a professor at Bar-Ilan University Faculty of Law, as well as the University of San Diego Law School. J.J. Surbeck is a Swiss-educated attorney who worked for 16 years for the International Committee of the Red Cross, the ICRC, which many have called the guardian of the Geneva Conventions. He has lectured and taught widely on the Geneva Conventions and their additional protocols, also called international humanitarian law. He is currently Executive Director of Team Training and Education About the Middle East, a nonprofit organization that is based in San Diego. Rick Richman is, from right here in LA, a graduate of Harvard College and NYU Law School. His articles have appeared in American Thinker, Commentary, the Jewish Journal of Greater Los Angeles, the Jewish Press, Pajamas Media, and the New York Sun. He blogs at Contentions and edits Jewish Current Issues. I would also like to take this opportunity to introduce Jennifer Dyer. Jennifer Dyer, who writes under the name J.E. Dyer, is a retired U.S. Naval Intelligence officer who served around the world afloat and ashore from 1983 to 2004. Her last operations in the Navy were Iraqi Freedom and Enduring Freedom in 2003, and she retired at the rank of commander. She lives now in the Inland Empire of Southern California, where she writes for various blogs and is preparing a book on the Cold War. Because of her background and the topics about which she writes extensively, she and I are working on a related symposium about the military and international law. Samples of her work are included in your handout. The format of tonight's panel discussion will be a little different than usual in order to elicit as much exchange among our panelists as possible. Each speaker will give an individual presentation, and afterwards they will have the opportunity to question and answer one another. Having been privy to discussions among these gentlemen in the planning of this event, I know you will find it as fascinating and informative as I did. If time allows, we will take questions from the audience at the end. The starting point for tonight's discussion is what Daniel Friedman calls the world's deadly obsession with Israel. He writes, "The simple solution for peace in the Middle East may be for Israel to change its name to Norway." Israel's diplomats discovered this trick in 1952 when an Israeli initiative at the UN for a ceasefire in Korea, put forward by Representative Abba Eban, encountered serious opposition only to pass easily once Norway replaced Israel as the sponsor. These experiences led Eban to later quip, "If Algeria introduced a resolution declaring that the earth was flat and that Israel had flattened it, it would pass by a vote of 164 to 13 with 26 abstentions." Israel is treated differently than other nations, and the first casualty is Israel's citizens, as its government is often pressured into taking actions contrary to its needs. Finding that balance between the needs of the citizens of Israel and the needs of her government, between security and international pressure, is the subject of our conversation tonight as we explore what is legal, what is just, what is possible, and what the probabilities are. Goldstone, international law, and the coming crisis in September. If you will kindly turn off your cell phones and other electronic devices, I'd like to introduce our first speaker, Avi Bell.
Thank you very much. Am I speaking close enough to this? All right, I'm going to try to keep my comments brief. I want to talk to you about the Goldstone Report, what it is, why it's important, what it is that recently led to a half retraction of the report, and what lessons we can draw from this entire episode. If you don't know, the Goldstone Report is a report that was produced by a mission of a fact-finding mission appointed by the UN Human Rights Council. It was headed by Judge Richard Goldstone of South Africa, hence the name. The other members are fairly anonymous to most of the world. Richard Goldstone was basically the face of this. I think that when the report was presented, Richard Goldstone held a press conference. It was the first time in the history of the Human Rights Council where a fact-finding mission was presented by a press conference. Goldstone took a number of efforts to pitch the merits of his report to the world. It probably was necessary to do so because the merits of the report are quite hard to find. It came in originally at 575 pages. I think the quip was that it ensured by its length that no one would ever read it. It was difficult to avoid criticizing the numerous flaws. The problem was to be able to fit these criticisms into some manageable format. There's a think tank in London, the Chatham House. They had a 2-day conference just on the procedural failings of the report. There's a report that came out afterwards on their criticisms. They're all, in my opinion, every single one of these criticisms is well based and doesn't even begin to touch the flaws of the report. Here they were, it's biased and prejudiced, with little analysis, hardly any references, aggressively biased, violated General Assembly rules on fact-finding, pre-selected witnesses by Hamas, incidents were selected for political effect, dismissively rejected Israel's extensive system of investigations. Now, after it did all these things, there are so many substantive flaws that I can't possibly go into them in the short time that's available to me. So I'm just going to pick out a few and talk about them. I think they're also useful in order to draw out the lessons that we're going to draw from this entire episode at the end of it. So let me just talk to you about 2 legal issues that came up in the report, among many. And then we can talk about what happened with them. All right, so here's number 1, international law of terrorism. Now, if you read the Goldstone Report, you wouldn't know such a thing exists. But there is such a thing. Right? So the standard cliche is that there is no definition of terrorism under international law, that one man's terrorist is another man's freedom fighter, that there's nothing that international law has to say about terrorism. Well, that happens to be pure nonsense, pure bunk. Right? Here you have a fairly popular treaty. What do I mean fairly popular? I think there are 170-something states that are party to this treaty, the International Convention for the Suppression of Terrorist Bombings. It has a definition of what constitutes acts of terrorism that are covered by the treaty. There are acts that cause or intended to cause death, or persons not taking part in warfare, where the purpose is to intimidate a population or compel a government or an organization to do or not do a thing, or if it's any one of these acts that's listed in a whole bunch of other anti-terrorism treaties, such as hijackings, taking hostages, unlawful acts of violence at airports, etc. Right? A whole bunch of treaties you have on terrorism. Who is a terrorist? Well, it's not only someone who carries out such an attack, but it's also those who organize or direct others, or cooperate and otherwise contribute to the commission of these offenses when one knows that that's what's going to be done. Right? There's a wide variety of people that are terrorists under this treaty. There is no freedom fighter excuse under this treaty, right? They're under no circumstances justifiable by considerations of a political, philosophical, ideological, racial, ethnic, religious, or other similar nature. And there are legal duties that attach to this. A state that's a party to this treaty has the duty to punish the offenses of terrorism. Okay? Now, it's not the only one out there. There's this treaty, the International Convention for the Suppression of Terrorist Bombings, and perhaps most importantly, there's a Security Council resolution that was adopted shortly after 9/11. by Chapter 7 of the UN Charter, which means it is legally binding on all state members of the UN, that is basically all states in the world. And among other things, it requires that all states refrain from providing any form of support, active or passive, to entities or persons involved in terrorist acts. Okay, that's a fairly unambiguous legal duty. Okay. Now, the Goldstone Report concerned the Gaza war in 2009 between Israel and Hamas. What is Hamas? Well, I'm going to guess that with this audience I don't have to give chapter and verse of why it is that Hamas is a terrorist organization. And I have to guess that when you see comments like this on Hamas TV from shortly before the war, this will not surprise you that comments like this are made about the blessing of the annihilation of Jews. Now, what is the number of times that the Goldstone Report deals with the international law concerning terrorism? It never does. It's not important, right? Does it refer to Hamas as a terrorist group? No, not a single time. How many times does it reach the conclusion that Hamas committed an act of terrorism? Never. Does it ever mention even this minor important fact that Hamas seeks to destroy Israel? Now, the Goldstone Report has a 20-page, 40-year background to the Gaza conflict so that all readers will understand what it is that led to the conflict. Somehow or another, it never managed to mention that part of the background to this conflict is that Hamas seeks to destroy the state of Israel. Nor does it mention any of this lovely stuff that you'll find, such as the blessing of the annihilation of Jews in Palestine, or you can find all sorts of wonderful things if you ever read the Hamas Charter about the perfidy of the Jews, their control of the world, their being behind every war that's ever existed, and the best part is the secret organizations that they use to do it, such as the Freemasons. Now, there is stuff about Hamas and in the Goldstone Report. This is the kind of thing that appears in the Goldstone Report. So it doesn't talk about the international legal duty to refrain from providing even passive support to Hamas. No, it says the opposite. Right? Israel imposing economic sanctions on Gaza somehow or another constitutes an unlawful form of collective punishment, according to the Goldstone Report. And even better, refusing to provide support to Hamas, arresting members of Hamas, or refusing to provide them jobs is an infringement of their protected legal rights to political association and free speech. You know, you can't prevent Hamas from organizing in order to carry out its blessed annihilation of the Jews in Palestine. All right, so that's legal issue number one. I'm going to briefly talk about legal issue number two. It's something called civilian shielding. Right? What is civilian shielding? Civilian shielding is basically directing the movement or placing civilians in a place in order to use them to shield your own position, right? To use them to prevent the other side from firing at you. There's a related prohibition. It's called perfidy. Right? The act of perfidy is feigning of protected status, among other things. Excuse me. Pardon? It's the feigning of protected status, such as, for example, by using signs of the Red Cross in order not to be attacked. Okay, so did Hamas engage in this sort of thing? There are numerous reports. Here's just, for example, one. Right? Hamas set up headquarters in Shifa Hospital in Gaza. It's the largest hospital in Gaza. In doing so, it was committing an act of perfidy, right? It was adopting forbidden signs. It was using the medical personnel there and the patients there as human shields. So one of the charming things about the Goldstone Report is how it dealt with all these uncomfortable things. The Goldstone Report has a whole list of recommendations against Israel, about holding Israelis on trial before the International Criminal Court, placing them on trial in various courts in the world under a theory called universal jurisdiction. And it directed these primarily at Israel because that's all that the Goldstone Report thought was worth investigating. So if you take, for example, did the Hamas commit a crime of civilian shielding or perfidy in Shifa Hospital? Well, the Goldstone Report has a simple answer, which is it couldn't find any evidence to support the allegations by the Israeli government that Shifa is used as a military base. Now, why didn't it find any evidence? Well, you read in between it says the mission did not investigate the case of Al-Shifa Hospital. It didn't look, and therefore it didn't find. Now, isn't that convenient? So most of you go through the report, and what you'll find is that it's based on an investigation, it says, of 36 particular incidents. Every single one of these incidents, by coincidence, involves a single party as the accused. Who's that accused party? Israel. Okay. Now, when it came to Israel, in accusing Israel, of course, it couldn't still wouldn't suffice simply accusing Israel in order to find it guilty, but it did for the Goldstone Report. So I guess JJ is going to be talking more about the laws of war in relation to this, but this is a fairly typical way that the Goldstone Report and others deal with it, right? You have, in the laws of war, one of the important things is what the parties intend. So, for example, it's a war crime to aim at civilians. It's not necessarily a war crime if a civilian gets killed. It's a war crime if you aimed at the civilians. Right? Now, what did the Goldstone Report say? Well, civilians died. Israel must have committed a war crime. Why? Because Israel has sophisticated technology, and therefore no errors occurred. If a civilian is dead, Israel must have aimed at him. Now, there's other charming bits to this report that I wish I had time to go into. You know, like there's this bit about pop psychology, for example, where they quote a Palestinian psychiatrist explaining that the Palestinian in the eyes of the Israeli soldier is not an equal human being, sometimes even becomes a demon. It's because of a state of paranoia. Right? This is the sort of in-depth psychological examination that the Goldstone Report included. But we'll have to leave it at that and move on to why is this important, right? Why is this document, the document number 2 million from the UN that condemns Israel, important to us? Well, the point of the document was to make sure that Israelis get put up on criminal charges around the world, and that's in fact what happens. Right? So here you have Tzipi Livni was threatened with arrest in South Africa, in the UK, on the basis of the alleged crimes that she performed that are proved by the Goldstone Report. Or here was Shimon Peres was in Switzerland a little over a month ago, I guess it was, where they sought to arrest him for crimes that were proved by the Goldstone Report. Now, does the Goldstone Report prove any crimes by Shimon Peres? Well, not really, but you know, still, it's still good for harassment. Right? The Prime Minister of Israel, Netanyahu, has described this as the Goldstone threat. It's part of a larger campaign in order to try to criminalize, in essence, the entire leadership of Israel. Any Israeli leader who goes abroad will end up in court. Even if they end up being acquitted in the end, it still makes it rather difficult to carry on diplomacy. It's also designed to support various actions to impose diplomatic and economic sanctions on Israel. It is a real threat. Now, about a month ago, Richard Goldstone published this sort of mealy-mouthed retraction. He said, well, if I'd known then what I knew now, the Goldstone Report would have been a different document. And maybe Israel didn't actually aim at civilians as we alleged over the course of 575 pages in the original report. Right, now, This isn't entirely, I think, honest when it says this is on the basis of new evidence, if he knew then what he knew now. If you go through the report, and unfortunately I don't have the time to do so, you'll see that it's quite clear that if the report had been based on the evidence in front of the committee at the time, it would have come up with very different conclusions as well. It should have come up then with the conclusion that Hamas committed war crimes and Israel did not, but it didn't. So why is it that Goldstone changed his mind to the extent that he did? Well, I think it's basically because he was confronted and embarrassed. Now, some of these confrontations were not substantive, right? So Goldstone was apparently confronted by members of a synagogue in South Africa where his grandson was to have a bar mitzvah, and he, for the sake of the family, so it wouldn't be embarrassed, pulled out of it. And there's also Goldstone engaged in a number of debates in high-profile locations where he debated racist Zionists. That would be me and Peter Berkowitz in this case. And was confronted with various claims that perhaps the legal claims in his document were not accurate. The result was a partial retraction. Now, is that the end of it? Well, unfortunately, it's not the end of it. Right now, formally, it's not the end of it because the document still exists. The United Nations is not going to withdraw it. The UN Human Rights Council is not going to withdraw it. The other 3 members of the mission continue to stand by it. But more importantly, it's because this is not a game of law; it's a game of politics. Right? So the document is out there. It's meant to be used in order to delegitimize Israel and to harass its leaders. Whether it formally has been retracted or not is not the end of the picture. Right? It's out there, it's spread its lies, the damage is at least partially done. And while it's a good thing that we now have this half retraction from Goldstone, and it's worth pressing forward to try to get more from him, more of a retraction, we have to understand that this is not the end of the game. It's always, at the end, about politics. Which leads me to the very last item that I want to mention. This is really a promo for something that Rick is going to be talking about, which is the coming crisis in September. Right there, basically, as we understand it right now, we're promised by the Palestinian leadership. In September, the Palestinian leadership is going to declare yet again that there is a state of Palestine, and it's going to be looking for UN support for this declaration. Now, as a legal matter, it's fairly easy to resolve what's going on here, right? There's 4 ingredients, maybe 5, to being a state. You have to have a permanent population, a territory over which this claimant is the highest sovereign, a government that is the highest sovereign government in that territory, and the capacity to carry on international relations. Some would say that in addition to these 4 ingredients, the entity has to be recognized as a state. Well, the Palestinians have a problem with B and C over here. We can debate whether they have a good claim overall to being a state or not. They're already recognized by more than 100 states. If they win or lose a vote in the United Nations, and of course they will win it, it's not going to change in any way the legal picture here. But of course, the legal picture here is not what this is all about. This is about politics. Right? The legal claims are simply dressing for political arguments. Now, it's important to confront the legal claims with counter-legal claims in a way that will eventually, we hope, force people to retract in the way Goldstone did. But it's also important to understand that as the name of the game is politics, it's also about making people feel uncomfortable in their positions. That is, I think, ultimately what it is that led Goldstone to partially retract to the extent that he did. And I think that it's important to make people feel uncomfortable when they take the kinds of unjustifiable legal positions that we see the Goldstone mission of having done and that we're going to see shortly again in the future. Thank you.
Good evening. Well, while I'm waiting for the light, I want to emphasize something that Avi didn't really emphasize, because he's a modest man. I think he played a really important role in getting Goldstone to recant his report. Because this debate that he was alluding to, where he was with Professor Berkowitz at Stanford, they had a strong exchange, and Avi is very good at debunking all the legal fallacies that you have in the Goldstone Report. So it looks like Goldstone, with that debate and a number of others, finally got jolted out of his self-complacency and realized that maybe, oh, he was wrong after all. I know there are different theories about that. Some people say that, well, he knew all along that he was wrong. But it's kind of interesting that he came along. Anyway, I don't want to spend too much time on that. We can talk about that. Well deserved. I'm going to talk today, right now, about where is international humanitarian law headed. So you'll forgive me for reading. I usually don't, but I thought that given the place and occasion, it would be better if I had a prepared text. Before I do, though, I do want to do one thing, and that is thank Doris Montrose for organizing this fabulous meeting. Thank you so much. You're very lucky here in Los Angeles to have someone who organizes such fantastic evenings and lectures. All right. Whenever Israel defends itself from external or internal attacks by its Arab neighbors or by Palestinians, the world resonates with accusations of quote-unquote war crimes allegedly committed by the soldiers of the Israeli Defense Forces, IDF. It happened in 2006 during the Second Lebanon War, when Israel responded to one Hezbollah attack too many, and it happened again in 2008, 2009, during Operation Cast Lead, when Israel, after 10 years of putting up with close to 10,000 non-stop rocket attacks, finally decided to teach Hamas a lesson that it wouldn't forget. And it happened again last year after the famous flotilla incident, during which a large group of foreign activists tried to reach the perfectly legitimate and lawful blockade Israel imposes there to prevent gun running by sea to Hamas. The same accusation flies every time a pro-Palestinian speaker takes the floor, usually on campuses across the nation, but also in countless editorials written by Palestinians or some of their friends. But what does that exactly mean? Not much, really. All it has going for it is a nice ring. War crimes sounds dramatic and horrible enough to conjure all sorts of rather unpleasant pictures, pulled from our respective memories, be they real-life experience or simply movies. But all of it is an easy slogan. Slogans are one of the pro-Palestinians' favorite communication methods because they're catchy, they're easy to remember, easy to repeat, and you don't need a first-rate education level to repeat them mindlessly, even if you don't even understand what you're saying. Beyond the theatrics, though, what are we actually referring to when we hear the two words war crimes? In order to give you a clear answer, I need first to give a very quick historical overview of international law in relation to the notion of war crimes. In the good old days of antiquity and the Middle Ages, the mere notion of war crimes would have been laughed at. Victors had absolute rights over the vanquished. Brute force ruled. Entire populations were slaughtered with abandon. So what has changed? Well, one day the world community, meaning primarily Western nations and paradoxically enough, most of them colonial powers, decided that the old rules of finishing off casualties on the battlefield and forcibly appropriating the vanquished populations, their lands, and their goods were not quite civilized enough anymore, and some restraints had to be introduced in the way nations behaved. What could have been more enlightening than that? Of course, it wasn't that easy. All habits die hard to this day. All we have to do is to look at Libya and Syria right now to see that some of the good old practices are alive and well. Nevertheless, starting in the 19th century, a number of rules, some national, some international, majority international as a matter of fact, started to appear. Let me jump quickly to the ones that are the most relevant in relation to the topic at hand. I'm referring here to what is called today international humanitarian law, more commonly known as IHL, and also referred to in many other quarters as the law of war or the law of armed conflict, LOAC. So what is IHL, international humanitarian law? It comprises essentially 6 international law treaties. The first 4 are famous all over the world. They are known as the Geneva Conventions. You all know the Geneva Conventions. You all heard about the Geneva Conventions. They're adopted in 1949, a mere 4 years after the nightmare of World War II. They reflect the collective trauma inflicted on Europe by Nazi Germany and on Asia by Imperial Japan. The first 2 Geneva Conventions protect specifically military personnel on land and at sea. The third one gives ample protection to prisoners of war. The fourth one, the one most often used as a weapon against Israel, bears a title that is, oddly enough, largely misleading. Its official name is Geneva Convention Relative to the Protection of Civilian Persons in Time of War. Why is it misleading? Well, because in fact, its provisions do not really protect civilians from the direct impact of hostilities, from the results of battle. They do not protect civilians from bombardment, for instance, or from direct attacks. This is a very common misunderstanding. What the Fourth Geneva Convention focuses on is the protection of civilians in territories occupied by a belligerent power. The reason is fairly easy to understand if you look back at history. After the innumerable violent abuses committed by the Nazis and the Japanese against innocent civilians during World War II, either taken as hostages or executed at random in reprisals, the world community was eager to adopt rules that would prevent this type of excesses from happening again. And that's the Fourth Geneva Convention. But now, here's where the notion of war crimes comes in. And there's a surprise, another surprise. The words war crime do not appear in the Geneva Conventions. Since it would have been impossible to put all infractions on the same footing, violations of the Geneva Conventions are divided between breaches and grave breaches. If you're Catholic, I was born and raised Catholic, so I can relate to that, and I'm assuming most of you are not, but who knows. It's like venial sin and immortal sin. Or in legal terms, it's comparing misdemeanors and felonies. The grave breaches are what we call today war crimes. Crimes such as torturing or murdering POWs or civilians, or any other category of individuals protected by the conventions. So when it comes to the civilian population, are civilian casualties caused as collateral damage to legitimate targeting of military objectives automatically to be considered as a war crime? That's what Avi was alluding to. The answer is yes, if the intent was to hurt these civilians, and no, if it wasn't. But it's not. But that is not on the basis of the Geneva Convention, whose list of grave breaches is limited, i.e., it's not open-ended. So what is the accusation of war crimes based on, then? We'll look at that in a minute. I must take another little detour first. I said that IHL, humanitarian law, was composed of 6 instruments. What are the other 2 on top of the 4 Geneva Conventions? Well, in 1977, the world community adopted 2 additional texts, known as the 2 additional protocols to the 1949 Geneva Conventions. These protocols are enormously important because they codify for the first time in history rules that, if adequately respected and applied, would really protect the civilian population from the direct impact of hostilities. In other words, it finally became clearly illegal to attack civilians as if they were legitimate military targets. It's not allowed anymore. Unfortunately, these protocols also changed the true and tried rules of warfare in a very negative way. In particular, they did away with two of the most fundamental conditions required of any combatants to be granted the status of and treatment of prisoner of war. The old rules known as the Hague Rules were straightforward. Every combatant to be deemed legitimate needed to, 1, be under responsible command, 2, wear a uniform or at least a sign that was recognizable, clearly recognizable at a distance, 3, bear its weapons openly, and 4, respect themselves the laws of war. If you met these 4 conditions, you were a legitimate combatant. Well, guess what? Under pressure from the same automatic majority that Israel is facing today at the UN, 2 of these conditions were removed. No need to bear a recognizable sign anymore, and no need to show your weapons openly anymore. So by eliminating these 2 fundamental requirements, the protocols put, in fact, the civilian protection in terrible danger, since the combatants are not required anymore to distinguish themselves from the civilians themselves, making everyone a legitimate target if suspected of being a combatant. Because of these unrealistic restrictions, both Israel and the US so far have refused to ratify the protocols. This left the agency that worked for years at developing international humanitarian law, and that is the International Committee of the Red Cross, my former employer that I used to work for 16 years. Well, the ICRC was not happy about this state of affair, but they had only, to a degree, themselves to blame. They were rather miffed about it. But sometime in 2005, they came up with a rather ingenious idea. They said, why don't we just forget about treaty law? Let's focus instead on customary law. And what does that mean? Well, what is referred to as customary law is a collection of customs that are recognized as old practices that have been around for a long time, centuries. They're honored and respected by all, so much so that they've never needed to be codified. One example of a universal customary rule is well known to everyone. What does the white flag mean? Surrender. Everybody knows that. It's universal. But customary law, by its very nature, has also one big advantage. It doesn't need to be agreed upon or ratified to be binding. It is already binding on all, including, and this is to our advantage, non-state actors. And this is, of course, rather seductive because given the proliferation of non-state actors today who hide behind the excuse that they are not states to reject their obligations under international law. So what the ICRC tried to do, in effect, was to borrow a new body of rules, the majority of which were in the additional protocols, and call them customary law. And voila! Ratification by Israel and the US is not necessary anymore. They are bound by the same rules anyway. It was a really sneaky approach, and it wasn't exactly well received by either country. At this point, the ICRC's efforts have, for all intents and purposes, stalled, but it did receive a lot of support, of course, from the usual majority. So here's what happens when the pro-Palestinians' voices pontificate that Israel has committed war crimes and violated the Geneva Conventions. To the extent that they even know what they're talking about, which is not always the case, they are in fact not referring to the Geneva Conventions, but instead to rules that exist only in the additional protocols. But since Israel is not bound by the additional protocols, then it doesn't matter because they consider Israel bound by those rules anyway, because these rules are also part of a new corpus of international law called customary law, created by the ICRC, of all people, of all organizations. But what people remember from these accusations, what they walk away with, is only the first part, that Israel violated the Geneva Conventions and committed war crimes, which is completely false. As always in these cases, accuracy is never the main concern of pro-Palestinian speakers. Their goal is to rile their listeners against Israel because, well, how could any country who claims to be civilized do such a ghastly thing as violating the Geneva Conventions? Never mind that the world is filled with cases of real violations of the Geneva Convention, so far worse, but that is of no interest to the pro-Palestinian crowd. Now, back to the Fourth Geneva Convention. There is one aspect of the Fourth Geneva Convention that has gained a lot of popularity among international law circles around the world and many governments, including our own. Pro-Palestinian voices are fond of accusing Israel of violating its Article 49, paragraph 6, which says, "The occupying power shall not deport or transfer part of its own civilian population in the territories it occupies." You know exactly what I'm alluding to. The disputed territories. The accusers, of course, are referring to the Jewish population living in Israeli cities built in the disputed territories and called settlements by most of the world. The error here lies in ignoring the intent of the writers of the Geneva Convention, who were not referring to who were referring to forcible deportation and transfer of their own population in occupied territories, which has never been the case of the Jewish settlers since they moved to the West Bank voluntarily. A more fundamental but also common misinterpretation of the Fourth Geneva Convention is to assume that the Israeli occupation of the West Bank is illegal. Here also, this is a faulty interpretation of the Convention. Its Article 2 states that it applies to situations of occupation resulting from a conflict between two or more high contracting parties. That's legalese for nation states that have signed the Geneva Conventions. Well, since we're talking about international law, by definition, these belligerents can only be nation states. When Israel conquered the West Bank in 1967, it did it in response to an armed aggression from three of its Arab neighbors, including Jordan, who had been illegally occupying the West Bank since 1948 as a result of the first war of aggression, which it waged against Israel in violation of United Nations General Assembly Resolution 181, which is the one that attempted to partition British Palestine between a Jewish state and an Arab state. As we all know, the Jews accepted. They created Israel. The Arabs rejected that proposal and immediately tried to destroy Israel. Result, Israel exists. There is no state of Palestine to this day. So when Israel conquered that territory in 1967, it was, in technical terms, a res nullius, a land that did not belong to anybody, left over from the Ottoman Empire, dismantled at the end of World War I. To sum up on this topic, the Israeli occupation of the West Bank is therefore not illegal, and the Fourth Geneva Convention doesn't apply, technically, even though Israel has honored its promise to apply most of its provisions as if it was legally applicable. And that, ladies and gentlemen, is remarkable. Not a single country in the history of the world has ever volunteered to do something like this, that I know of. An important clarification is needed here also. Many international law specialists, including the ICRC's very own lawyers, reject this interpretation and consider that Israel is fully obligated to recognize the applicability of Convention 4 to the disputed territories. Well, since I worked for 16 years for the ICRC, 10 of those in its legal division, I must disclose that I disagree with my former employer. Big time. What I would like to examine now here is whether the ICRC, for the most part in unison with the majority of the international community, has been applying these principles in a uniform fashion. If they did, then we do need to pay attention to their stringent interpretation of the applicability of the Fourth Geneva Convention. If they did not, then we are entitled to ask whether we are looking at a case of double standard, and if so, why it exists in the first place. Let's start with Tibet. In 1950, China invaded Tibet, declaring it one of its provinces and brutally conquered it before annexing it. In the last 62 years that has been there ever since, have the ICRC and the world done or said anything about this? No. Do they send regular press releases protesting the mistreatment of the Tibetan population by the Chinese occupiers? No. Do they protest the illegal occupation of Tibet based on the Fourth Geneva Convention? No. Did they protest the forcible transfer of hundreds of thousands of ethnic Chinese into Tibet? No. The reason is obvious. No one wants to criticize, let alone confront China. Next, we need to turn our gaze towards the Western Sahara. This former Spanish colony under Morocco, located under Morocco on the Atlantic coast, was illegally appropriated by Morocco in 1975 when the Spaniards left the place without leaving behind them an indigenous government. The same questions as above in the case of Tibet apply, with the same answers, except for the fact that the annexation started peacefully but degenerated quickly into a guerrilla war that is still ongoing today. So the question again is, does anybody care about Western Sahara being illegally occupied by Morocco? No. The answer is obvious. Did the ICRC protest this blatant and illegal land grab? No. Is it clamoring that Morocco is violating the Fourth Geneva Convention? No. And finally, let's consider the case of Cyprus. For the sake of brevity, I will skip to the circumstances that led Turkey to invade and brutally occupy the northern half of Cyprus in 1974, removing in the process all the Greek population from that area and bringing in Turkish settlers to replace them. To this day, the Turks are still illegally occupying the northern half of the island. And the question is, while the ICRC was involved in helping the victims of that conflict, it has not condemned Turkey for not applying the Fourth Geneva Convention or for violating its rules. So the lesson to be drawn from all these three cases are clear. There is a double standard at play. The reason is relatively easy to understand. Realpolitik. The original German word is Realpolitik. The ICRC, like most of the world, is very vocal when it criticizes Israel, or the US for that matter, because it knows fully well that it has no reason to fear retribution of any sort from these two countries. The same cannot be said of China, Turkey, Morocco, countries who have shown to have singularly thin skins and bristle at the slightest hint of criticism regarding their respective illegal occupations and appropriation of territories that do not belong to them. This fundamental inequity must be kept in mind when one considers the way the world as a whole, with the open support of institutions like the ICRC, treats Israel. A clear double standard emerges. Israel is expected to respect all the rules of international law and is harshly criticized for the slightest perceived offense, not to mention situations where offenses are created out of thin air like the Goldstone Report. But on the other side of the equation, murderous regimes that have killed scores of their own citizens or others through terrorism do not even receive a slap on the wrist. Why? Again, a not-so-courageous world, including a not-so-courageous ICRC, only dare criticize countries or groups that they don't have anything to fear from in harsh and sometimes lethal retaliation. I'm almost done. I know, I promise. I'm over time. Okay. There is no shortage of voices claiming that this is not a double standard, but that it simply reflects the heightened sophistication of Israeli society as opposed to the impoverished condition of the Palestinian people, hampered as they are by the, quote, occupation, quote, of their land, quote, unquote. Therefore, Israel is deemed more responsible than the Palestinians are. What that line of thought really means is that the Palestinians have not reached the capability of functioning as a sovereign and responsible nation. Is it a valid excuse? I think not. When a new nation appears on the world scene, they not only acquire rights, they also acquire duties. The Palestinians are no exception. More broadly, we are now witnessing a disturbing tendency to use international law at the behest of the Palestinians as a tool to attack Israel exclusively. Witness the pathological obsession against Israel that pervades the United Nations and dominates its Human Rights Council. Witness the rash of lawfare cases where the otherwise valid concept of universal jurisdiction is abused to launch unwarranted lawsuits against Israeli officials under phony accusations of war crimes. Witness the amazingly biased judgment rendered by the International Court of Justice against what it persisted to call the Israeli security wall, blithely ignoring the reason for the security fence's existence in the first place: Palestinian terrorism, the most egregious violation of international humanitarian law. This trend is worrisome and needs to be addressed, lest the world community ends up in a not-so-distant future with two different categories of countries: the ones that honor and pay attention to their international legal obligations, and the ones that do not; the ones that submit their behavior to the constraints of international law, and the ones who ignore these constraints. Soon a choice will have to be made. Either the same rules apply to all, or they do not apply to anyone. There cannot be two regiments coexisting at the same time. To advocate such a formula is to call for chaos in the international arena. To conclude, what is the solution? The short answer is that we demand, forcefully if need be, that all countries abide in the same way to the same rules, in particular human rights and humanitarian law rules. Thank you very much.
Well, it is an honor to be on the same panel as Avi Bell and J.J. Surbeck. I asked Avi for permission, and he kindly gave it, for me to reprint at Jewish Current Issues the opening statement he made in the debate with Justice Goldstone, and I did so not only because it is a devastating critique, as devastating as the one he made this evening, but also I think a historic document, and I commend it to all of you. J.J. Surbeck's reputation as one of the premier experts in international law precedes him, and then there's me. I'm going to speak about the coming crisis in September, which refers to the fact that in September, the Palestinians will request recognition of a Palestinian state with borders on the pre-June 1967 lines, which are really the 1949 armistice lines in the first Arab war against Israel, on land that is legitimately occupied by Israel as a result of a defensive war in 1967, and whose final status under multiple UN resolutions, international agreements, and formal U.S. letters issued by successive U.S. administrations of both political parties to Israel is supposed to be the subject only of direct negotiation between the parties and not resolved by the unilateral action of either of them or by a UN diktat. So you can look at this coming car crash in September through three different prisms. First, through the prism of the moribund peace process, which for quite a while has been a non-peace, non-process. Second, through the prism of U.S.-Israeli relations, which seem to alternate between the administration's Chicago-style diplomacy in odd-numbered years and charm offensives in even-numbered years. And you can look at it, third, through the prism, the broader prism of the role of the United States and its reputation in international affairs. I'm going to look briefly at all three prisms, and I'm going to conclude that the dangers of the coming UN resolution are far greater for the United States than they are for Israel. That there will be a test for Israel, but it is going to come not in September, but in May, that is to say next month. And it will be a different sort of test than the one that people currently think is coming. So to start with the effect of the UN resolution on the peace process, recall that 8 years ago, both Israel and the Palestinian Authority formally adopted the roadmap of the quartet comprised of the United States, Russia, the UN, and the EU. The quartet always reminds me of the answer to one of Karnak the Magnificent's questions: name a superpower, a former superpower, and two organizations with no power. What happens in the quartet is what the U.S. wants to happen. The quartet cannot even meet if the U.S. does not want it to meet. So if the roadmap fails, it will be a massive U.S. failure in a peace process that the U.S. has invested nearly 8 years, and really 2 decades if you start with Oslo, in an effort to culminate in a Palestinian state in a legal fashion, meeting the principles of international law that both Avi and JJ discussed. So as you all know, the roadmap called for 3 phases. First, a sustained effort to dismantle Hamas and other terrorist organizations. Second, a Palestinian state with provisional powers and provisional territory. And third, final status negotiations on the issues of borders, Jerusalem, refugees, and security. But no effort was ever made to dismantle Hamas. And after the Palestinian legislative election of 2006 and the Hamas coup in 2007, compliance with Phase 1 became impossible. The Palestinians also categorically rejected Phase 2, and the U.S. never insisted that they abide by it. Instead, in the last year of the Bush administration, the roadmap was accelerated, to use Secretary Rice's term, to skip Phase 1 and skip Phase 2, and a year-long Phase 3 final status negotiation ended when the Palestinians rejected the Israeli offer of a state on 100% of the West Bank after land swaps and with a shared Jerusalem. Secretary of State Rice has said privately, she said it privately, but she also said that she privately urged the Palestinian president to accept the offer, and ex-Prime Minister Olmert has disclosed that he all but begged him to accept it, but nothing happened. The Palestinian recourse to the UN will mean that not only Phase 1 and Phase 2, but Phase 3 of the roadmap will have been discarded. You cannot go to the UN for a determination on a final status issue and have it determined without negotiation and without reference to any other issue, and pretend that any phase of the roadmap still remains. So the non-peace, non-process will be not only moribund, but dead. Benjamin Netanyahu could offer a new peace plan or new concessions when he speaks to Congress next month, but they will be rejected by the Palestinians out of hand. The U.S. could offer its own peace plan, as the New York Times and J Street are urging President Obama to do, but it will meet the same response and make the U.S. look powerless and foolish in the process. So what do you do if you want the peace process, such as it is, to continue? We'll come back to that. If you look, secondly, at the coming UN resolution through the prism of U.S.-Israeli relations, you will find that the U.S. is virtually committed, through multiple assurances to Israel in connection with prior withdrawals from the West Bank and Gaza, to oppose any plan in the UN that would render the roadmap dead. In 1997, when Israel withdrew from Hebron and turned it over to the Palestinian Authority, the U.S. Secretary of State Warren Christopher issued a formal letter to the Israeli Prime Minister, who was then Benjamin Netanyahu, stating the U.S. position that borders were to be resolved in direct negotiations in which Israel would be entitled to defensible borders. And in 2004, in connection with the Israeli withdrawal from Gaza, the U.S. issued another letter to Israel, signed by President Bush, reassuring Israel of the steadfast commitment of the United States to defensible borders and to the roadmap as the sole Middle East peace plan. The term defensible borders is an undefined term, but no one reasonably thinks they are the 1967 lines. So when the Palestinians go to the UN in September, the consequences for U.S.-Israeli relations will be profound. If the U.S. permits the adoption of a resolution regarding a Palestinian state with borders that are not only not negotiated, but indefensible as well. The result will be not only the end of the roadmap and the peace process, but a crisis in U.S.-Israeli relations far greater than an announcement of Jewish housing in the Jewish area of the capital of the Jewish state. It is doubtful that any president, especially one who must face the American electorate a year later, would take that course of action. On the other hand, this is a president who made a Palestinian state one of his central foreign policy objectives, literally from his first day in office, and he is someone who agonized over the last resolution the Palestinians brought to the UN just a few months ago. Which brings me to my third prism, the role of the U.S. in world affairs. If the U.S. cannot, this coming September, preserve its own roadmap process and cannot stop a resolution that seeks to have a Palestinian state recognized in a manner that violates not only the provisions of the roadmap, but multiple U.S. assurances to Israel about the outcome of the peace process, then the damage to the United States and its president will be profound, much greater than for much greater than the damage for Israel. For Israel, it will be the adoption of yet another anti-Israel resolution by a notoriously anti-Israel institution that will have no effect on the ground. In the real world, as opposed to the world of UN resolutions, it will make the emergence of a Palestinian state less likely rather than more. For the U.S., however, the consequences will be much more severe. It will be a demonstration of extraordinary diplomatic impotence, particularly after the president personally warned the Palestinians that there would be repercussions if they went to the UN for a resolution last time, have it make more concessions, threaten its prime minister with no Oval Office pictures next month unless he includes significant concessions in his speech to Congress, in the hope that pre-negotiation concessions might convince the Palestinians to resume negotiations that will go nowhere but at least spare you the coming debacle in the UN. But it will be a demonstration that the Palestinians, instead of suffering repercussions, will have shown that they can get the United States once again to lean on its own ally, and it will not be the last time that strategy is employed either by the Palestinians or by others. So there is another approach that, in my view, would be more productive for both Israel and the United States. Israel is currently dealing with an unelected West Bank president about to start the 76th month of his 48-month term, who rules by decree and lacks the political legitimacy to engage in serious negotiations, even assuming he wanted to. And you have Gaza ruled by a terrorist group that is sworn to destroy Israel. But they have now announced a unity government and a commitment to hold an election within the coming year. It is doubtful, in my view, that Fatah and Hamas can live side by side in peace and security with each other, much less with Israel. But the surest way to find out, in my view, is to proceed to hold that election. So in his speech to Congress, Netanyahu should reiterate that there cannot be two states if the Palestinian one is not ready or willing to recognize a Jewish one with defensible borders, that both Democratic and Republican administrations have formally assured Israel must emerge from direct negotiations, and that the Palestinians should proceed to hold the elections that they have now agreed to hold, and to elect leaders willing to recognize Israel, renounce terrorism, and abide by all prior agreements, or not. Netanyahu should say that the place for further concessions is not in a speech, but in negotiations with a democratically elected Palestinian authority prepared to make concessions in return. And he should express the hope that the Palestinians will elect a government with the authority to negotiate on that basis. And the United States should respond that the way forward is not an empty UN resolution that will kill the peace process, but the establishment by the Palestinians of a functioning democracy. Because if you are not able to hold an election or to elect leaders committed to peace with your neighbor, then you are obviously not ready for a state, either as a matter of law or as a matter of politics. and the repercussions in that event ought to be obvious. So the title of this evening's presentation refers to a crisis coming in September, but in my view the key events will happen next month, with Netanyahu's speech to Congress and Obama's reaction to it. And only if both countries make it clear at that time that the UN gambit of the Palestinians is not an acceptable way to proceed, only in that way can either country avoid the crisis that's coming in September. It seems to me that the worst way for Israel to proceed is to negotiate with itself and offer up concessions that will be both pocketed and declared insufficient at the same time. It is better to announce adherence to a certain overriding principle, recognition of a Palestinian state in exchange for reciprocal recognition of a Jewish state with defensible borders, and pronounce yourself willing to negotiate with the Palestinians once they demonstrate their own commitment to that principle in a new election that is already more than 2 years overdue, and which the Palestinians, all of them, have told us this week they are prepared to hold. Such an election will, in my view, produce what used to be called moral clarity, and it will have the important side benefit of getting us past the coming crisis in September. Thank you.
Thank you very much to that wonderful panel. The next thing on the agenda is what we're going to call the lightning round, and that will allow each of the three panelists to respond to the points of interest for him from what the others have said. What I'd like to do is take about 5 minutes for each gentleman in turn to make some points that he came up with listening to the others, and then open it up for just discussion between them. And we want to keep this whole thing to about 20-25 minutes with the making the points and the discussion. So we'll do that, and then as soon as that's done, we'll open it up to Q&A, which Doris will honcho for us. Avi, if you'll go first. Okay.
I wanted to actually respond to what Rick just talked about. I guess this is a little bit out of my field. I should be talking about law, but I'm going to be talking about politics. And this is because I think the name of the game here is, in fact, politics. So what is it that's going on in September? I'm not sure that I see it the same way that Rick does. What is the game that is being played? Is this a game for another anti-resolution? I don't think it's a game for another anti-resolution. What is the Palestinians are attempting to achieve? What they're attempting to achieve is the Goldstone effect. What is the Goldstone effect? It is you make some ridiculous claims and you dress them up in fancy legal language in an attempt to get third-party actors to do things for you. So it's not about, it doesn't end with the language. It ends with what the third parties are going to do for you. The Goldstone Report is supposed to end with Israeli leaders being arrested. The Palestinian state gambit is supposed to end with sanctions, diplomatic and economic, against the state of Israel. I think that's where the game is being played. Now, who is supposed to engage in sanctioning Israel? Who is supposed to impose these diplomatic and economic sanctions on Israel? I think that it's supposed to be the states of Europe, the ones that see these kinds of empty rhetorical devices as meaningful. Now, what can be done? I think that it's probably true that one way not to confront this is to try to concede some political gesture. It's because it's not about the Israeli concession. It's about the rhetoric as part of an ongoing diplomatic conflict. I think that a better way is to confront the emptiness behind the rhetoric, to try to force those third parties, the Europeans in this case, to be embarrassed if they follow, in fact, the gambit that the Palestinians are proposing. Now, I really think is saying this about the U.S., that one of the things to try to do is force the U.S. to confront that it will be embarrassed if it supports this. And I have to say that it may be a little bit late here, because if we're talking about the U.S. being losing credibility by supporting it, well, the U.S. should be losing credibility earlier. Rick says, well, let's look at what happened. Let's see what, maybe we're best off by looking at what happened in the elections between the Fatah and Hamas. Now, the U.S. made some commitments on the PLO before it made commitments about a Palestinian state. Now, these are the commitments the U.S. made on the PLO. The U.S. recognition of the PLO was based on PLO forswearing violence and terrorism. Now, there is a member organization of the PLO called the Palestinian Front for the Popular Front for the Liberation of Palestine. Now, Israel just arrested the two terrorists that murdered the Fogel family less than a month ago, and they are PFLP terrorists, a member organization of the PLO. Now, under U.S. law, that means the U.S. has to withdraw its contacts with the PLO, whose chairman, by the way, is the gentleman that Rick mentioned, the person now entering his 76th month of his 48-month term as president of the Palestinian Authority. That would be Mahmoud Abbas, chairman of the Palestine Liberation Organization. Now, is the U.S. going to do this? I don't think so. Now, we talk about Fatah as if it's the peaceful alternative to Hamas. Hamas, there's no doubt, is a terrorist organization, but you may be surprised to know that more Israelis were killed by Fatah terrorists in the last decade than Hamas terrorists. That doesn't mean that Hamas is good guys. It means that maybe Fatah is not good guys. So when we talk about the fact that they might lose credibility by supporting this camp, we have to remember that it doesn't happen automatically. We have to put these issues out in the open to force a confrontation, diplomatic or otherwise, about the previous issues before we can be assured that the next one will be taken care of. We want to make sure the United States doesn't support a unilateral state. Well, maybe we ought to call the United States on its continued support for the PLO.
Let me make 3 points. The third one will agree with you. The first 2 points I was trying to make is, one, that September, I think, is too late to stop this train. If we get to September and the train has not been stopped, or a car crash makes my metaphor, it will, in fact, be unstoppable. Because if the United States does not indicate before that time that it is standing with Israel, then people will interpret that the United States might abstain, or that it might demand concessions from Israel as the price of a veto, and that will have an impact that will affect September. So you have to act now, rather than wait till September. That's number one. Number two is, I think one of the things we have learned is responses on the merits don't actually have a tremendous impact. Because for the reasons that you said, that it's a matter of politics, not law. So you can read to the UN and to the world the 4 requirements under international law for a state. And it will fall on deaf ears because they want the Palestinians to have a state. They wait so long. We don't care about the requirements under international law. So you have to act before September, and it has to be an action that's not responsive or defensive or complaining. It has to be something where Israel takes command of the situation and proposes something, which can either be a new plan with new concessions, which is what everybody thinks Netanyahu is being pressured to do, or it can be something along the lines of what I suggested, which is to take the Palestinians at their word that they are ready for a state. I myself don't think that election, if scheduled, would actually ever proceed. Whoever thought they were going to lose would start the civil war, which in effect would lead to, hopefully, the implementation of phase 1 of the roadmap, the dismantlement of the terrorists in the Palestinian Authority. If the elections turn out fine and they elect somebody ready and willing to negotiate with Israel, then fine. If it's somewhere in between, at least it will have identified the nature of the putative state that Israel's up against. And that is why I think one needs to think about something other than waiting for September and relying on international law.
Right, hard to beat that. Avi, I have a question, a legal question for you. When you talk about the the international law conditions that are required for a state to be recognized, you mentioned a few criteria. In the last few years, we've seen the appearance of new states on the world scene. There was, of course, in the 90s, all the former Soviet republics. Then we had a few remnants of colonies, like Timor became independent through a pretty nasty war with Indonesia. More recently, we had Kosovo. What differentiates all these new... Oh, and I'm forgetting Southern Sudan, excuse me, that just became... is going to become a state in July after a 25-year civil war and a referendum, and the whole population voted to become independent, secede from Northern Sudan. So you have blacks, Southern Sudan, seceding from Arab Northern Sudan. So all these countries, new countries, what differentiates them from quote-unquote Palestine?
A state has to have, these ingredients count for every one of the candidates you mentioned. So what is it that makes them states? They would be states if they have a functioning government there that actually is in control of the territory. Now, why is it in southern Sudan that there's going to be a functioning state there in control of the territory? Because the North is leaving, and leaving new government in control of that territory. What happened in Timor? Same thing. Government left. What happened in Kosovo? Well, the government was convinced to leave. The Serbian government was convinced by NATO bombing and NATO troops to leave. But you have to have a government taking control of that territory in order for there to be a new state. Now, is the Palestinian Authority in control of the West Bank? There are Israeli soldiers deployed throughout the West Bank. The Palestinian Authority is subordinate to Israel on the West Bank. They can become a state if Israel withdraws. So it could... If in the meantime, the Palestinian Authority can declare anything it wants, it is not a government in control of that territory. Now, interestingly, that's not the case in Gaza. What would happen if they decided, let's say, if Hamas today wanted to declare itself to be a state in Gaza? I'm not sure there's any barrier to that. I don't think they have any particular interest in doing so.
I have a comment about the Goldstone Report and a question for Avi about it. The comment is that it's not generally recognized that Israel itself produced 3 lengthy reports before the Goldstone Report, during the time the Goldstone Report was being prepared, and after it came out, analyzing what happened in the Gaza war. The reports themselves total more than 500 pages themselves, and they were basically ignored by the UN, by Goldstone himself. So my question on that is, in light of that, would it have been any different if Israel had participated as part of the Goldstone process? And since there will be another one at some point in the future, should Israel participate at that point in time?
Okay, so this is one of Goldstone's standard lines. It is that he was forced to adopt these false conclusions because Israel did not cooperate with the mission. Now, it's clearly not true as a matter of law. It's that one is forced, if one party does not go along with a fact-finding procedure, then one is forced to adopt conclusions that one knows to be incorrect. It may be that there are legal proceedings in which there are parties with a burden of proof and parties without a burden of proof, but of course this was not one. And the Goldstone Report is fairly clear about the fact that not only did it not have any standards of proof, it didn't have any presumptions except for presumptions of guilt about Israel, right? So no need in our case for presumptions of innocence. But if you look at the Goldstone Report, it actually does cite the Israeli submissions, right? It says the Israelis, for example, I actually quoted one of them, right? The Israelis say that Shipley Hospital was used as a military base, but we don't accept that. Why don't we accept it? Because we're not interested in investigating it. So it's, to the extent that Israel did cooperate, the Goldstone Report simply blew it off. It was not interested in it. None of the evidence would be accepted. So is it true that it would be different if Israel cooperated? I don't think so. Now, there's a political question. What's what empowers Israel best to fight it? Is it cooperating or staying away? Now, I can think of one case where it helped Israel to refuse to cooperate. That was after the allegation that Israel committed war crimes in Jenin. Initially, the reports were that Israel slaughtered 500 civilians, then it was 150 civilians, and then it was 100 civilians. And as is the way of the UN first voted to find Israel guilty and then dispatched a fact-finding mission to find the details about Israel's guilt. Now, in that case, Israel refused to allow them to land in Israel at all. And eventually, several months later, the UN issued its report, and the report admitted the truth, which was there was no massacre. There was a fight in which half the casualties were civilians and half the casualties were Palestinian terrorists, and there was no war crime. So in that case, it seems to me at least that in that one case, that failing to cooperate, refusing to cooperate, embarrassed the UN into that response. And so I don't know if that's universally true. I don't know that it's, at least in this case, refusing to cooperate with Goldstone didn't help, but I don't think it hurt either.
I think we should let the audience ask questions now. They made the effort of coming here tonight.
I just want to ask that you limit your speech to a question.
Gentlemen, I compliment you on your learned experience and your knowledge. I used to be a friend of Richard Goldstone, and he was my lawyer at one stage. Things have changed. A peace accord between Hamas and Fatah, and that is what I think is the unterste of what's going to happen. So I'd like you please to address that.
Well, we obviously don't know what's going to happen in Egypt. And to a certain extent, Egypt is a much different situation from an electoral standpoint than the Palestinian Authority, because the Palestinian Authority has had experience with a prior election that was certified as free and fair back in 2006 by virtually everybody, which was won by Hamas. And the Palestinians have been able since then to see what happened in Gaza from rule by Hamas. They've also been able to see what's happened in the West Bank as international funds have been poured into that area by the international community. And so they have the ability to vote in a system and with a certain amount of knowledge that the Egyptians don't actually have, since the Egyptians are coming off of a 30-year authoritarian rule without real political parties other than the Muslim Brotherhood. So actually, I think that an election in the Palestinian Authority would be a different animal than the one that we would have in Egypt. I agree with you that the one in Egypt is equally as serious, but I think they are two different situations.
Well, I'll start off with the question. My question will be, what is your response to the following? I think Avi Bell put his finger exactly on the issue when he said it's not so much the legal considerations but the political claims. Legal arguments are only relevant so far as they further the legitimacy as opposed to the legality of the political positions adopted. That basically means that things like the Goldstone Report are a symptom of the deeper malaise, a symptom rather than the illness itself. And in some ways, dealing with such detail, we're spotting mosquitoes rather than invading the swamp. And what is the swamp? The swamp, I think, as I say this as an Israeli, the swamp is the lack of resolve of the Israeli government to win the diplomatic war, and the incompetence of the Israeli leadership in conducting its public diplomacy. Because if you really want to understand phenomena like the Goldstone Report and the flotilla debacle, The reason is very simple, very difficult to accept, very easy to prove. Israel is losing the media war and generating phenomena like the Goldstone Report because it doesn't want to win. It doesn't want to win, or at least the people conducting the war have a world view which doesn't allow them to adopt a winning strategy. And you're going to see that as September comes along as well, where Netanyahu, instead of defiance, will demonstrate compliance. There are many things he could do. He could say to the administration, gentlemen, you are forcing me to hand over the holy city to the Muslims. Next week, with plausible deniability, I will bring John Hagee and 5 million evangelical Christians into Washington and shut down the capital until you recant. If the Palestinian state is declared, we will cut off all services, water, fuel, electricity, postal services. If you want to be independent, be independent. And if you pump out more water than agreed in the Oslo agreements from aquifer, that's a pulse failure. So I think there should be a strong, one thing you should learn from J Street, you should send a strong message to Israel, the message opposite to J Street's message. But I think the Israeli government is completely misinterpreting the mood in the Jewish communities abroad, and I think we should send them a strong message. What's the response?
Well, I think for those of you who don't know, we should identify the speaker, who's Professor Martin Sherman, one of the preeminent professors and writers in Israel. And I think your question was, do I agree? And so my answer is yes.
Can I take a crack at disagreeing? So let me take the part that I disagree with. First of all, I don't think it's correct to say that that is the swamp. There's this common disease. It's on the left and the right to see this as primarily an Israeli problem. If Israel does this or that, the problem will go away. The diplomatic war against Israel is not waiting for Israel's approval. And it's not going to end no matter what Israel does. There's a question of what is the best strategy to respond to it. But under no circumstances should we fool ourselves into thinking that it is relying upon Israel doing this or that. Now, there's a question of what is the best response to the diplomatic war. And so I think that it's a fair statement to say that retreat or constant retreat is not a very good strategy. That said, you also have to pick your battles about where it is that you want to confront and move forward, and which are the battles that are best not handled. Particularly if you're talking about diplomatic wars and public relations wars. Public relations wars, in part, are not about how you fight them. They're about what are the issues you choose to fight. What are the issues you want to put on the table, and which are the issues that you'd rather not address at all. In general, I agree with you that retreat is not a very good strategy. I'm not sure that the particulars are the best strategy for fighting the PR war.
You touched on one very important aspect, which is the PR war, precisely. Tonight I talked to you about humanitarian law. That's because it's something that I know about. It's a part of my past, but it's not my main occupation. What I do on a daily basis is to give workshops and seminars to educate people who don't know the facts of the Middle East conflict. And it really starts there. Each and every one of us, and in particular in the Jewish communities of this nation, we need to know all the facts. All of you, I'm ready to bet, have been engaged in intense debates with family, friends, relatives, colleagues, what have you, over Israel. And there are huge arguments. What I'm finding is that a lot of people are finding themselves tongue-tied because here they receive these accusations, genocide, and you name it, apartheid, and they know that it's baloney, but they don't really know how to answer to them. So I think it really starts there. All of us, each and every one of us, we have to do our homework. We have to learn the facts. We have to learn how to respond to these accusations. And there's another aspect of that, which you also touched on, which is I get people, when I give my lectures and classes, I mean, it never fails. Every single time there's at least one person that says, oh, but Israel is not doing enough in the world of PR. They're not giving enough money, it's not their priority. And my answer has been for years, stop blaming Israel. It's not going to happen. They have their own problem. What we need to do is take care of our own PR battle where we are here. And Doris is doing a fabulous job here in LA in this respect. It's a very good illustration. And I think I would really encourage each and every one of you to pick up that battle. Each and every one of you can become a real active Israel advocate. If all of us did that, we could really make a big difference.
Mr. Surbeck partially answered the first two of my questions in his response just now, but the first question was, I appreciate him addressing Tibet in regards to double standards, but I'm very uncomfortable in even mentioning Tibet in regards to Israel, or for that matter, South Africa and apartheid, because of how frequently you confront it in the media. And I've worked with kids before in radio, and that's a question and an assumption that they make a lot is zero difference between Israel and apartheid South Africa, or Tibet, because it's easy to grasp. If possible, I was wondering if any one or two or all three of you could give your elevator pitch, if you will, of why you cannot equate Israel to China or South Africa. My second question, which I guess is unrelated, is we seem to be operating, our rationale seems to be operating under the assumption that the Palestinian leadership, Hamas and Fatah, want a state. Is that an assumption, a fact, or false?
Okay, so I'll take my crack first, and I presume that my colleagues will join me. So let me start with the second one first. There's this assumption that they want to stay. I don't actually assume that. I don't believe that there's any indication that the Palestinians, either Fatah or Hamas, actually are interested in a state. I think that it's a diplomatic gambit as part of a larger campaign. There is a state in hand to be had. It would be a very interesting thing if they took Gaza, which has a Palestinian government, has territory, has the capacity to carry on foreign relations, has a permanent population, and treated it as a state, which the rest of the world would obviously go along with. But there is no interest in doing so. The interest is in declaring the West Bank, which is not one, to be a state, because that is more interesting and useful in a diplomatic confrontation. So I don't see any indication that, in fact, either of these parties is particularly interested in the Palestinian state. So it's not an assumption of mine. The first question was, what's the elevator pitch for why Israel is different? Well, there are a million reasons why Israel is different, and I think that's the wrong thing to ask yourself. Because your elevator pitch is never going to be, let me explain to you why I'm not a child molester. Right? If the moment that that's my elevator pitch, I'm in the wrong business. Right? So the whole point of all these accusations, Israel's apartheid, Israel is China, Israel is like China and Tibet, is to make that the issue. It's to have Israel well, we're not a part of it. Well, of course Israel's not a part of it. What are we even discussing this for? This is not something that should be addressed. This is not something that Israel should expend efforts in pitching to the world. Israel is not an apartheid state. What Israel should be doing is, besides pitching its accomplishments, is running negative on the people who made these outrageous claims. They're the people that you want to talk about. That's the issue that you want to pitch. What you want to pitch is why they're libelous, not why I'm okay.
I completely share Avi's, what can I call it, maybe more aggressive attitude. I think too often you have people who are really kind of cowed by the pro-Palestinians, who are themselves very aggressive. Well, we need to stand our ground and be just as aggressive, but we have to know what we're talking about in order to do that. So that is really where it starts. Knowledge, knowledge, knowledge. You have to start there. Once you know your facts, then it becomes a real fun game. I can tell you that. Give you one quick example. Well, let me address very quickly the apartheid question. There are different ways to respond to the apartheid one, but I found one recently that I thought was pretty fabulous. Would it have been conceivable under the apartheid regime in South Africa for a black person to be a judge? South Africans in the room? Was it possible? There were African judges? Okay, with authority over white people? Did they have jurisdiction over white people? Of course not. I mean, that would be the negation of the whole philosophy of apartheid. Can you imagine a black judge in apartheid South Africa presiding a 3-judge panel to indict the president of the country for sexual abuse, for rape, excuse me? Inconceivable. Well, what did just happen in Israel? An Israeli Arab judge presided a 3-judge commission to indict ex-President Kassab for rape. Where's apartheid in there? So that's really just one example, but there's like half a dozen examples like this that you can use, and usually, you know, that's pretty efficient to shut them off. Another thing that you need also to remember when they talk about apartheid is you always turn around the question. Ask them, what is apartheid? I mean, define for me what is apartheid. I hear this word all the time, I don't understand. So right there you will find that you put them on the defensive because quite often they're incapable of explaining to you what really apartheid was, because it doesn't exist anymore. Let me give you another example. And that is the accusation of genocide. I use this one all the time, especially with students on campus, and I have a lot of fun with it. They come to me and they say, Israel is committing genocide against the Palestinians. And I go, oh my God, really? That's horrible. But can you tell me exactly what is genocide? And they tell me, well, you killed everybody. And I said, you know what? You're right. That's the definition of genocide. The 1948 Convention Against the Crime of Genocide defines what genocide is. And in so many other words, that is what it is. You kill everybody, physically eliminate all the members of a specific group. So we are in agreement. But let me ask you another question. How many Palestinians were there in 1948? And most of the time, they won't be able to tell you. So you held them. Okay, 150,000 in what became Israel. They stayed there. 600,000 fled, and 50,000 roughly were actually kicked out because they were in strategic places. So we're talking 800,000 Palestinians. Agreed? Yeah, whatever. Okay, third question. How many Palestinians do we have today? 1.5 million. 1.5 million in Israel, 1.2, 1.5, 3.54 million between the West Bank and Gaza and the Palestinian diaspora. So let's go back to the definition. If we agree that you kill everybody, how do you explain that the numbers went from 800,000 to shot to past 4 million? Don't you have a problem with that? Oh, well, yeah, okay, fine. I shouldn't have used the word genocide, but I meant massacre. I said, use massacre if you want, but do not ever use the word genocide again, because it's an absolute slander, and it's not a reflection of reality. You make them look stupid, and it works.
Just a very quick response on the assumption point, because it's a very perceptive point. It is an assumption that the Palestinians want a state. It's an assumption that they want a second state. It's an assumption that if they got one, it would live in peace and security side by side with Israel. It is clear that it would be an apartheid state because they want every Jew removed from it. And it is further an assumption that this should remain a central part of American foreign policy now that the Palestinians have refused on 3 separate occasions a state on substantially all of the West Bank with a shared Jerusalem. And finally, it is an assumption that if you met all of these other assumptions, it would have any other impact on any other dispute in the Middle East or anywhere else in the world. And somehow, in the sense of being proactive instead of defensive, those who support Israel need to put those assumptions on the table and ask American commentators and foreign policy people, why should a Palestinian state be a central objective of American foreign policy at all?
I want to say something. There is a video going around that shows the people who started the whole idea of calling Israel an apartheid state. And they say that never in their imagination, wildest imagination, did they think it would catch on the way it did. And the reason it caught on the way it did is because our side, pro-Israel side, uses the word apartheid in defending ourselves. So every time we say we're not apartheid and myths about apartheid, we are actually promoting what they came up with. So we have to stop defending, like Avi said, we have to stop defending what we're not. And don't use the word apartheid. I'm going to get, there's just one more question because it's getting late. This is Jennifer Dyer, and as I've introduced her before, she is a writer, an author, and she blogs under Hot Air and Commentary, and she has her own blog called The Optimistic Conservative, and she's going to get the last question.
Thank you, Doris. I'm really glad that Doris said that because it was a great lead-in to my question. So often what we're doing is letting the falsities put out by the other side be the proposition. That's all that we end up talking about. And one thing I really like about Rick's proposal is that it resets the proposition, his proposal that Hamas and Fatah held to this promise of conducting an election, and that an elected government be a precondition for the agreement to going ahead and instituting the state. It really doesn't even matter whether we get back on the roadmap or not, I think. It resets the proposition to give them something that they have to be held to, something they have to answer to. So, with that said, my question is, when it comes to international law and the things that Israel is always having to defend herself on, is there any kind of effort out there to reset the proposition instead of just constantly dealing with defense against falsities, to change the way that we're thinking about that? And I honestly don't know. I don't know if there's anything out there that is looking to do that.
Okay, I have a suggestion. I just want to preface it by saying I don't think it's the way to reset things is to set up a future challenge. And because we've done this before, right? We've set up future challenges and they failed them, and then the results have been ignored. We've set up yet another challenge. Right? So there were elections in which they were challenged, right? Choose Hamas with the assumption Fatah's peace and Hamas' war, or Hamas' terrorism. The Palestinian people chose Hamas. The U.S. government ignored the results and pushed through the Annapolis process anyway, right? So I don't know why the future challenge will lead to any different results. I think push on the last one, push the U.S. to pay up on the previous commitments, and then we'll talk about whether it's worth doing this challenge again. Now, on the specific question, right, how does one reset things? I think one resets things by going on the diplomatic attack. So here's my suggestion. Okay, the Palestinians went to the International Criminal Court. They gave in a letter on behalf of the state of Palestine,
that they accept the jurisdiction of the ICC to prosecute Israelis for all crimes committed with respect to Gaza. Right? Now, if it were up to me, what I would do is I would flood the ICC prosecutor with complaints about Palestinian war crimes committed with respect to the Gaza conflict. Now, will the prosecutor prosecute those cases? I very much doubt it. But there are several good results anyway. First of all, let's argue about that. Okay, let's argue about the war crimes that they committed and whether the prosecutor is willing to file the charges or not to file the charges, and who it was among them, the criminals. That's number one. Number two is, it's going to be really hard for the prosecutor to decide to try Israelis about alleged crimes with respect to Gaza when the prosecutor is refusing to prosecute the real war crimes committed by Palestinians. So if the question is how do we set things, I would go start filing charges. By the way, you don't have to do it only in the ICC. You know, Cindy Livni, everywhere she goes, they're filing arrest warrants for complete nonsense. Well, why is it that Abbas can go around the world when it's quite clear that there are Palestinian crimes against humanity and war crimes for which he has not answered? Now, maybe he will be found guilty, maybe he will be not. I presume that nobody will actually try him, but let's give it a shot. Let's put that on the table. Let's have people arguing about that.
Absolutely, in total agreement. Jennifer, you put your finger on really one of the key issues that we're all facing, and that is, until recently, I think it's starting to change for the better, but we still have a lot of work to do. We have been entirely in reactive mode. And what we need to do is really change gears and go on the offensive and be proactive. That's what we need to do. We need to have a lot more lectures on, a lot more articles published. There's a whole campaign that needs to be done. The problem is that the Palestinian side is pretty much is better organized than we are. It's the big paradox in this whole affair. Here is Israel, this incredible miracle of a nation in 63 years that has accomplished so much, whose people, and not only Israelis, but of course Jewish people all over the world have and do excel in every conceivable field in the world under the sun, except PR. What is their problem? Now you look at a Palestinian, it's exactly the reverse. They have accomplished nothing. They have succeeded in nothing. The only accomplishment that what they have brought to the world is terrorism. But when it comes to PR, they have an incredible machine. And they are doing very, very good work. And that we haven't yet learned how to copy that. So they do a lot of things that we should really emulate and counter that. And they have the dollars, of course, too. And yes, that's another factor, of course.
I just ask you one minute? I want to strongly disagree. Okay. There is a chaos to democracy, and it's a wonderful thing. And it's a weakness and it's a strength, but it's more of a strength than a weakness. Yeah, Israelis speak in millions of different voices, and that's the way democracies work. If the question is, how do we organize a response like this, the answer is, it does not have to be organized. Right? Anyone here with sufficient initiative can go ahead and do this. The Israeli government does not have to turn to the prosecutor of the ICC. Any lawyer here can write out a series of complaints and do that. The Israeli government does not have to go around the world asking for charges to be filed against the boss. Any lawyer can do this. It is not, I don't think there's a problem here of lack of organization. I think the lack of organization is fabulous. Right? I think that's exactly what we need. That is our strength. We should take advantage of it.
I don't think we disagree because what you're saying, and I really, really agree with it, is that we have two completely different cultures facing each other. On the one hand, you have a fairly uniform message with a system that is in essence totalitarian. We come from a system, our values, and this is America and Israel have the same values of democracy. Everybody has an opinion, and that's true. There is a cacophony. I think within that cacophony, all I'm saying is that there could be more cooperation and more initiatives. Right now, it is a cacophony, but it hasn't been enough to match what has been happening on the other side. And if we're dealing with these international situations, especially on the diplomatic PR front, that are not in the favor of Israel, I think it has something to do with that. So yes, there's a lot of work for us to do. I wanted to briefly mention, I didn't want to ignore your question about Tibet, so I'll be happy to talk to you about that later. Ray, you want to say something?
You know what? Yeah, no, I'm just going to mention something that seems small but actually is large, which is that all of you who can should attend the APAC policy conference next month, because the number of people who are there, and Netanyahu and others who will be speaking, will be important, and you will learn an incredible amount in a couple days. Any of you who have been to the conference know that is true, and it will arm you with information and relationships that you'll establish there that will enable you personally to carry on this fight. So if you're not planning to go, you should go.
Thank you very much, everybody. Thank you, J.J. Surbeck. Thank you, Avi Bell. Thank you, Rick Richman.
Thank you. It was very, very, very